Hi, this is the business guy with Asset Protection Planners. My team and I have set up literally thousands of trusts for clients, and today we're going to go over Living Trust 101. So let's take a closer look at how these work, why they're so important, and how they can make a significant difference in your estate planning. Okay, now understanding the life of an asset. To understand living trusts, you need to first understand the life of an asset. Assets are the things that we accumulate during our lifetimes, like houses, cars, bank accounts, investments, and personal belongings. These are often titled in our names. For example, if I have a car in my name, several bank accounts, if I pass away unexpectedly, these assets remain in my name. The Department of Motor Vehicles, DMV, or equivalent in your state, would need to know who is entitled to that car. Oh, and if you appreciate this information, you're entitled to click the subscribe button if you haven't already, because I really want to see you again. Okay, now this is where estate planning becomes crucial: how you hold your assets. During your lifetime, how you hold your assets matters. For instance, let's say my wife and I have a joint account as joint tenants with rights of survivorship or tenancy by the entireties. Either way, this means that if something happens to either one of us, the other one automatically inherits the assets. This form of ownership is simple and avoids some probate issues, but what happens when both of us pass away? Every estate must deal with the distribution of assets when the owners pass away. The complexities of asset distribution. If you have a small amount of assets, you might avoid some extensive probates, sometimes called small estate probate. For example, you might not need a full court proceeding to transfer a car title. You might be able to file a few declarations and avoid a painful legal process. However, if you have significant assets like a house, bank accounts, investment accounts, or a business, that's when it gets more complicated. Let's break this down to 3 ways that assets are handled after death. Number 1, we call intestate. Intestate means no will or estate plan in place. Your assets are distributed according to state law, which often leads to probate. Think of celebrities like Prince or Aretha Franklin, who passed away without a will. Their estates went straight into probate. For instance, if you own real estate in multiple states, you must go through probate in each state. Now, probate can last about 18 months in the US and take about 20% of the estate's value. This means that you'd have to go before a judge and get the judge's approval before inheriting anything. So the court oversees the process, notifying creditors and beneficiaries, which can lead to conflicts and legal fees. In fact, I speak from experience, seeing my clients go through this before they contacted us. It's a lengthy and costly process, draining both time and resources. Okay, that brings us to the second type, and that is a will. A will also goes through probate, so that has to go before a judge as well. You outline who gets your assets, but the court still needs to verify and oversee the process. And this can lead to disputes among heirs. For example, there was a case in Georgia where siblings litigated over a $6.95 Barbie doll from their mother's collection. The legal fees far exceeded the toy's value. Probate can be expensive and time-consuming, especially in states like California, where it can start at 8% of the estate's value. It's really like adding kindling to a fire. Family disputes can ignite quickly, leading to prolonged and costly litigation. We've seen it break apart families left and right. In fact, Marilyn Monroe did have a will when she died at age 36 on August 4th, 1962. She had today's equivalent of about $7.5 million. However, her probate process wasn't settled until 2001, nearly 40 years later. Probate took 54% of her estate, or the equivalent of $4 million that went into the lawyer's pockets. Now, on top of that, she left the majority of her estate to her acting coach, Lee Strasberg, who she said was like a father to her, and his second wife, Paula, who would die in 1966. Now, Lee got remarried, and then he died in 1982. So the majority of what was left of Marilyn Monroe's estate went to Lee's third wife, Anna Strasberg, somebody who Marilyn Monroe had never met. So therein lies the danger of probate. It can suck the estate dry financially, it's prone to constant challenges, and can drag on for years. So that leads us to number 3, the living trust. Now, living trust avoids probate altogether. It's private, not a public record, and it doesn't require a judge's involvement. For example, when you put your house into a living trust, It doesn't need to be probated. The trust names a trustee to manage your assets, which is usually you, and it outlines how they're distributed. Now, during your lifetime, again, you can be the trustee, and if you become incapacitated, a successor trustee takes over. This flexibility allows you to manage your assets while you're alive and ensure they're distributed according to your wishes. And number 4, I'm going to let you in on a little secret, an asset protection trust. A living trust provides little to no asset protection when you're alive. So somebody suing you can generally seize everything in your living trust as if it was in your own name. An asset protection trust, on the other hand, when properly established in the proper jurisdiction with an independent third-party trustee company, can both provide estate planning to avoid probate and asset protection. Now, we typically stick an LLC inside of the trust so that you can be the LLC manager when the legal waters are calm. You open your bank account in the name of your LLC, and you're the bank account signatory on the bank and/or investment accounts. Now, there are 2 categories of asset protection trusts. There's domestic and offshore. Now, we've seen domestic trusts penetrated left and right by results-oriented judges. So that leaves the offshore trust, which offers the most powerful asset protection of all. Now, jurisdictions such as the Cook Islands, where our organization has set up more trusts than anybody in the world, Nevis and Belize offer some of the most protective statutes. Cook Islands is part of New Zealand, which Transparency International names as one of the most trusted jurisdictions in the world. So you can name your living trust as the subsequent beneficiary of your asset protection trust, so that when you die, everything that was in your asset protection trust is now handled by your living trust. Alternatively, you can utilize the estate planning provisions in the asset protection trust itself. Okay, creating a legacy. Now, when my mother died on Christmas Day of last year, naturally, I had set up a living trust for her. Well, you only lose your mother once. So though I had set up thousands of trusts for clients, this is the first time I got to experience the use of a living trust for estate planning purposes firsthand. Though it was very difficult to lose my mother, the trust made the process as smooth as butter. No judges, no courtrooms, no probate, no attorney's fees. My sister and I simply took over her bank accounts and paid her bills for her until she passed away. We took over her medical decisions because that was covered. We put her in the best nursing home money could buy. We sold her house as the trust allowed us to do that. And when she passed away, my sister and I divvied up the proceeds, and we did that just as the trust dictated. A living trust also helps create a legacy. For example, if you value education, you can set up the trust to cover educational expenses for your descendants. You might also include provisions for travel, requiring heirs to travel or learn about other cultures, funded by the trust. This way, you can instill your values and ensure your assets are used meaningfully. In fact, I've created trusts where heirs are encouraged to get their doctorate degrees in order to receive an inheritance, and the trust pays for it. And that's what Shaquille O'Neal did. As he puts it, if you want to touch daddy's cheese, you need to have 3 degrees. Modern affordability. Now, living trusts used to be expensive, but now they're way more affordable, often costing a fraction of what probate would cost. Now, for more free information, you can visit assetprotectionplanners.com. And if you're serious and not just curious, contact us. If assets are still in your name at death, a small estate process can transfer them quickly if there's no other beneficiaries. For instance, if you still have a car in your name, it's a low asset estate. Okay, now comprehensive estate planning. A comprehensive estate plan with a living trust covers your lifetime needs, including periods of incapacity, and also ensures that your wishes are followed after your death, unlike a will, which only takes effect upon death. A living trust is active during your lifetime. It includes ancillary documents like a living will, medical power of attorney, financial power of attorney, and provisions for minor children. Okay, now here's some misinformation about living trusts. The level of misinformation about living trusts is really surprising. Many lawyers still recommend wills without disclosing the potential probate costs. There are usually probate attorneys who like to stuff their filing cabinets with their clients' wills. That way they get paid someday to take it through probate. Now, it might sound attractive on the surface because a will is cheap to create, but probate can cost your estate significantly more. In fact, AARP studies show that the high costs and long timelines of probate, especially post-pandemic. So as we said, lawyers often push wills because they can generally generate more legal fees through probate. So let's go through some practical examples to illustrate the benefits of a living trust. Case number one, avoiding probate with real estate. Suppose you own properties in different states. Now, without a living trust, your family would have to go through the probate process in each state individually, one by one. Talk about a nightmare. If these properties are in a living trust, your heirs avoid the cumbersome process of probating in multiple states. They can quickly and efficiently take control of these assets without the lengthy legal battles. Number two, protecting heirs for themselves. Imagine you have a young heir who isn't financially savvy. A living trust can include stipulations that distribute funds gradually based on certain milestones, like graduating from college or reaching a certain age, such as age 30. This prevents the heir from squandering their inheritance and buying a Lamborghini in every color, and provides a safety net for their future. Case number three, ensuring business continuity. This is supposed to be a factory with a smokestack if you didn't know what that was. If you own a business, a living trust can ensure a smooth transition of ownership. You can designate a successor trustee to manage the business, ensuring it continues to operate seamlessly without disruption. Case number four, health and education provisions. You can set up a trust to fund health and education expenses for your descendants. This ensures that your legacy supports their well-being and personal growth, aligning them with your values. Now let's address some common objections to setting up a living trust. Cost. Living trusts are more affordable than ever. The initial cost is significantly lower than potential expenses of probate. Complexity. While creating a living trust might seem complex, the long-term benefit far outweighs the initial effort. Plus, professionals can help simplify the process. Lack of assets. Even if you don't have substantial assets, a living trust can still be beneficial. It provides peace of mind and ensures your wishes are honored. So here's some final thoughts on living trusts. In conclusion, a living trust offers flexibility, privacy, and control over your assets, as well as leaving a legacy. It's a comprehensive tool that can save your estate time, money, and potential conflicts by planning ahead and ensuring your loved ones are cared for and your values are preserved. If you found this information useful, please subscribe, follow if you haven't already, click like, share it with others who might benefit, and don't hesitate to leave a comment below with your feedback or suggestions for future topics. Now, before we wrap it up, let's touch on creating a legacy through your trust. If you want your future generations to know who you are and what you valued, this is your opportunity. For instance, if you love travel, you can set up provisions in your trust to fund annual trips for your descendants, encouraging them to explore the world. Or if you believe in charity, you can require your beneficiaries to engage in charitable work to receive their inheritances. This ensures that your values are passed on to them and that your assets are used meaningfully. Creating a living trust allows you to maintain control over your legacy. It's not just about distributing your assets. It's about ensuring your wishes and values are honored. You can set specific conditions for your inheritance, like requiring your heirs to complete their education or stay free from substance abuse. Imagine if you want future generations to understand the importance of hard work and philanthropy. You could set up a provision in your trust that allocates funds to be used for charitable purposes, or perhaps a scholarship fund in your name that supports education for underprivileged students. And this not only helps those in need, but also instills a sense of purpose and responsibility for your heirs. Okay, encouraging responsible behavior. Another benefit of a living trust is that it can encourage responsible financial behavior. For example, you might have an heir who is prone to spending impulsively. By setting up a living trust, you can ensure that their inheritance is managed by a trustee who can distribute funds based on specific needs like education, housing, or healthcare, rather than allowing a lump sum that could quickly be spent. Planning for incapacity. A living trust is not just about what happens after you die. It's also about what happens if you become incapacitated. If you were to suffer from a serious illness or accident that leaves you unable to manage your affairs, the successor trustee that you appointed could step in to handle your finances like my sister and I did for our mother, ensuring that your bills are paid and that your assets are managed according to your wishes. This provides an extra layer of security and peace of mind for you. Flexibility and control. Now, one of the key advantages of a living trust is its flexibility. You can amend or revoke the trust as your circumstances change. For instance, if you acquire new assets, you can easily add them to your trust. If your relationships or priorities change, you can adjust the terms of your trust to reflect your current wishes. This level of control is invaluable in ensuring that your estate plan remains aligned with your goals throughout your lifetime. Privacy. Privacy is another significant benefit of a living trust. Unlike a will, which becomes a public document, by the way, once it goes through probate, a living trust remains private. This means that the details of your estate, the identities of your beneficiaries, and the nature and value of your assets do not become public record. So this can help protect your family's privacy and reduce the risk of disputes or challenges from disgruntled heirs or opportunistic creditors. Avoiding probate. Let's not forget the primary reason many people choose a living trust: avoiding probate. Now, probate, as we talked about, can be a lengthy and expensive process. It involves court fees, attorney's fees, and other administrative costs that can significantly reduce the value of your estate. Remember the Marilyn Monroe story. Moreover, probate proceedings are a matter of public record, which means that anybody can access the information about your estate. So by avoiding probate, a living trust can help ensure that your assets are distributed quickly and privately to your beneficiaries. Charitable giving. If philanthropy is important to you, a living trust can facilitate charitable giving. You can specify that a portion of your estate goes to your favorite charities, either in lump sum or through a charitable remainder trust that provides ongoing support. This can help you leave a lasting legacy and support causes that are meaningful to you. The Bill Gates family has helped stop the spread of many diseases in Africa. Deceased billionaire Howard Hughes and his medical institute, William Hewlett of Hewlett-Packard, and so on, establishing a legacy. Finally, a living trust allows you to establish a lasting legacy, and you can include specific instructions for how your assets would be used, whether for education, travel, philanthropy, or other purposes. You can even create a family foundation or scholarship fund to support future generations. By clearly outlining your wishes, you can ensure that your values and priorities are reflected in the way your estate is managed and distributed. So in conclusion, a living trust is a powerful tool for estate planning that offers flexibility, control, privacy, and the ability to create a lasting legacy. So whether you have significant assets or just want to ensure that your loved ones are cared for, a living trust can provide peace of mind and security. So if you found this information useful, please subscribe to our channel, share it with others who might benefit, and don't hesitate to leave your comments with your feedback or suggestions for future topics. And thank you for watching. This is The Business Guy.